In this audio, I'm going to discuss the various student visa categories: F for Freddie, J for Jam, and M for Mother, FJ and M visas. F1 is a student in an academic or language training program. F2 will be for the spouse or child of an F1. J1, exchange visitor. J2 is the spouse or child of J1, main applicant. M1, a vocational student or other non-academic student. M2, spouse or child of the M1 applicant. Student and Exchange Visitor Information System, the acronym SEVIS, S-E-V-I-S, is a record of your definitive student status. So you must still present the paper form I-20 for the F or the M. Often when I'm speaking to clients, they will tell me, I went to a place of study, whatever it is in the United States, and they can't give me an I-20, but they said it's okay. They'll be able to issue me with a student visa, whether that be an F or an M. And I will tell that person, as I'm going to tell you, if whomever you wish to study with, whether it is academic, non-academic, vocational, and they are not able to issue an I-20, then you cannot get a visa with that institution. So you should not be paying them, because you're not going to be granted either an F and or an M visa. You will need to present a Form DS 2019. This form typically gives you the start and the end date, the expiration date of the visa that you have been approved for. This is typically for the J visa. But the SEVIS record is the definitive record of student or exchange visitor status and visa eligibility. So you're always going to have to check the applicant's SEVIS status. Officers will want to verify that the SEVIS fee has been paid. So all of these visa categories, the F, M, and J, they are non-immigrant visa categories. They are temporary visas. It means that you wish to enter the United States for a finite period of time, that's temporary, and you will return home to your home country at the end of your temporary stay. These visas do not permit you to apply for an immigrant visa classification. So you can't apply for a green card. They're non-immigrant visas. When you are going through your interview at the consulate, an officer will presume that you are an immigrant visa applicant. This is how they treat everybody. This is the standard on how they adjudicate. The legal standard, the burden is on you to prove that you only wish to enter temporary. And that is why officers will be looking at things such as home ties. Will you return home at the end of your temporary stay? Many times I encounter clients who will have been inside the United States for a various amount of time under a previous student visa classification. For whatever reason, they now wish to re-enter again. Maybe they want to do advanced studies. Maybe they now want to do a master's or a PhD. Just, I'm giving you a hypothetical so you can understand. This is something I hear quite a lot. And even though they will present themselves at the consulate, they'll have all the correct documentation. They will even have good home ties. They'll have all the documentation to show that they will be returning home and that they did in fact already return home at the end of their preceding studies. They didn't overstay. They didn't work unlawfully. They didn't breach any of the terms of the visa, etc., etc. An officer is going to be very circumspect and cautious into now approving them for an additional 2-4 years. The officer's thinking to themselves, well, hold up. You've already been inside the United States for years. Now you wish to go back in for several more years? That's a phenomenally long period of time for me now to permit you to re-enter for. So they're going to be very circumspect because, yes, you're permitted, but it makes them nervous. How do you convince an officer in this situation? And I always advise clients, you want to be able to support why you need these further studies. It's not just enough to tell the officer, well, it's been always my passion that I do a master's, or I want to be called a doctor by doing my PhD. That's not enough. Why do you want to do these advanced studies? Why are you putting yourself through the time, expense, and effort? Why are you wishing for a long period of time, albeit temporary, inside of the United States? And a way to support this that has been successful, and I have used it in my office, whereby people have called me and said, "Carol, I've gone in. I had nothing to do with their student visa application. They're now calling me saying, I went to the consulate. I was looking for additional time. The officer wouldn't give it to me. Can you help me?" And typically, I will advise them, are you able to support why you want to do these studies? And a very good way to support that is, do you have a prospective, a future employer in your home country or outside of the United States? Doesn't even necessarily have to be in your home country. Is that employer attracted to you and willing to give you prospective future employment at the end of your now proposed additional studies? In other words, because of what you will achieve from your studies, employers are more attracted to you. They're more willing to give you a position because you have what others do not have in that field. And if you can show that, that is one of the examples of how you would shore up and underpin your reasons why you are justifying that you want to now enter the United States for a longer period of time and to re-enter the United States and do further studies. So it's not enough to just say, it's a passion of mine. I'm the first in my family to have a master's. They don't care about things like that. They want to know, why are you doing this? And it has to be a probative reason. They want to understand, why are you wishing to do further studies? Because their concern is, if they let you in, you may never return. You have already set up a lot of ties in the United States. You probably have many friends, even family, because you've been already there for years. They're concerned, are you now going to return home if I give you an additional 2 or 4 years to do these extra studies? So you have to have a legitimate reason as to why you will return home. And one of those legitimate reasons is because you're trying to advance and further your career. By doing these studies, you will attract more employers. And you have an example where you've maybe reached out to an employer, and that employer is willing to say yes. Should he or she achieve this academic achievement, then we would be definitely interested in interviewing them and or employing them in the future. They don't per se have to offer you a place of employment. I mean, it's years in the future, they don't know. But because of your credentials that you're now going to get by being inside the United States for an extended period of time, they would be more interested in employing you in the future. So be careful and be mindful of that, because I do see this coming up over and over, where people wish to re-enter the United States and they want to stay longer because they want to advance their academic time in the United States. So a bit of an overview for the F or M visa. It's really required for individuals to enter the United States to attend university or college, public or private secondary school, private elementary school, seminary, conservatory, or other academic institution, including language training program, or vocational or other recognized non-academic institution. If you come from a country where you are permitted to apply for a visa waiver, the ESTA, the 90-day, and you intend to study inside the United States, you cannot utilize a visa waiver to do that. Nor can you utilize a B visa, except to undertake recreational study incidental to your visit. So the primary purpose cannot be to the study. Any study that leads to a degree or certificate conferred by either a US or foreign educational institution is not permitted on a B visa, even if it's for a short duration. For example, distance learning, which requires a period on the institution's US campus, requires a student visa. Let's go through the requirements to qualify for a student visa. This is a student visa F1 or M1. 1. Acceptance at a school as evidenced by a Form I-20. 2. Intent to enter the United States solely to pursue a full course of study at an approved institution. 3. Present intent to leave the United States at conclusion of approved activities. So this is the intent to depart. Do you have sufficient home ties to substantiate and cooperate this? 4. Possession of sufficient funds to meet the individual needs. Officers critically look at financials during these interviews. 5. Preparation for course of study. And if you fail to meet one or more of the above criteria, you will be refused under 214B ground. In other audios, I have discussed in great detail home ties, 214B denials, and these will all be pertinent to a student visa. Officers, both at the consulate and port of entries, are on lookout for the following because they see a lot of this. Fraud related to Form I-20. Now, I had mentioned institutions telling you don't need an I-20 to come over and study with us. But on the other side, fraud as it relates to the F&M candidates, where an applicant may have submitted false records to institutions to secure the Form I-20. Officers will always be on the lookout for unusual patterns of Form I-20 issuance by particular institutions. Any type of fraud will trigger a 221G refusal. And I have discussed 221G refusals in other audios. So under both the F and M categories, you must have a residence abroad. This is a requirement. And it specifically must either, you must have a residence abroad. This is where you reside. This is where you live primarily. Have no immediate intention of abandoning this residence and intend to depart from the United States upon completion of your approved activities. Now let's see how adjudicating officers look at the residence abroad, slightly different for students versus, for example, under a student B2, a tourist B2 or a business B1, because typically students will be going into the United States for years, at a minimum 1 year. Officers will adjudicate from the following. They will consider the applicant's present intent. That's at the time of the interview in determining the visa eligibility, not what they might do after a lengthy stay inside the United States. If a student visa applicant is residing with parents or a guardian, they are maintaining a residence abroad if they have satisfied that they have a present intent to depart the United States at the conclusion of their studies. So you're going to be looking seriously at what is said at the time of your interview about your residence and your intent to depart. It doesn't matter, for example, your intent may change. That won't be a sufficient reason to deny your visa. Also note that your present intent to depart does not imply the need to return to the country from which you hold a passport. Your plans might be at the end of your studies, you might be going to a different country. But the intent at the time of the interview is you will depart at the end of your studies. I'm just going to touch a little bit more on the adequate financial resources, because they are very important to an adjudicating officer. They are stringently adjudicated, and an officer is always going to look at these. So for an F1 student, when you are satisfying sufficient funds to cover expenses, you must provide evidence that you have sufficient funds to successfully study inside the United States without resorting to unauthorized US employment for financial support. The personal funds sources can include scholarships, fellowships, and approved on-campus employment. You are permitted to be employed on campus, and there's a time period in which you can start working on campus. So officers are not expecting you to have cash per se immediately available to cover the entire period of your intended study, which may, for some students, many students, be several years. That's not expected. You must, however, establish, and they're looking for this establishment through credible documentary evidence, that you have enough readily available funds to meet all expenses for the first year of study. And you would satisfy this by presenting evidence for, example, maybe a student loan. But the mere intention to obtain a loan, officers will deem this to be insufficient. You actually have to have already the loan in place. Just a note here on medical insurance, because I'm often asked this. F&M students and their dependents are not required to have US medical or travel insurance to qualify for a visa. Also a note here on if the applicant will be receiving funds from a source outside of the United States. So often if an applicant indicates that the financial source will be coming from outside of the United States, for example, maybe parents living in a country of origin, a different country, then the officer is going to look at whether there are restrictions on the transfer of funds from that country. And they're going to expect you to provide evidence that these restrictions will not prevent the funds from being made available during the period of the applicant's projected stay inside the United States. So funds from outside of the United States are okay. They're just going to be looking, are there restrictions in transferring those funds? Periods of stay under F1 and M1 applicants. So let's discuss the F1 applicant first and their period of stay permitted. So an individual entering as an F1 student or granted a change to that status is usually admitted or given an extension of stay for the duration of status. Duration of status will normally be annotated D-S or DS, and it means the time during which the student is pursuing a full course of study and any additional periods of authorized practical training, plus 60 days following completion of the course or practical training within which to depart. That 60 days is typically referred to as the grace period. An academic student is in status during the summer months between terms, if eligible and intending to register for the next term. The student is expected to resume a full course of study at the commencement of the next term. A student compelled by illness or other medical condition to interrupt or reduce studies is in status until their recovery. A student is expected to resume a full course of study upon recovery. Period of stay for M1 applicants. The period of stay for an M1 student, whether from admission or through the change of non-immigrant classification, is the time necessary to complete the course of study indicated on Form I-20 plus 30 days within which to depart, not to exceed 1 year. That 30 days is also referencing this grace period that I have mentioned. An M1 student may be granted an extension of stay if it is established the following. The student has a bona fide non-immigrant currently maintaining student status. The student is able to and in good faith intends to continue to maintain that status for the period for which the extension is granted, and the student has compelling educational or medical reasons which resulted in a delay to the course of study. Delays caused by academic probation or suspension are not acceptable reasons for program extension. Spouses and children of F1 and M1 students. Before the F2, that's for the spouse and child of an F1, or the M2 spouse and child of an M1 is issued. So before the spouse and child get their visa issued, the principal F1 and M1, their visa must be issued. You have to satisfy the relationship between the principal applicant and the spouse and the child. So you're satisfying that relationship with the spouse, marriage certificate with children, birth certificates with a name on. I often get asked this, so I'm going to address it here. For spouse and children, are they able to attend school in the United States? A spouse qualified for an F2 or M2 or any other derivative non-immigrant classification may only study in those studies that are incidental to the primary purpose of travel, to accompany their spouse to the United States. So a spouse in F2 status, therefore, can only participate in avocational or recreational programs. A spouse of an F1 visa holder may only enroll in a full-time course of study if they independently qualify for their own non-immigrant visa as a student. A child qualified for an F2 or M2 or any other derivative non-immigrant classification is not required to qualify as a non-immigrant student, even though the child will attend school while accompanying the principal. A child in F1 status could not qualify to attend a public primary school and would be limited to 12 months of attendance at a public high school. Employment for F1 and M1 students. So let's discuss the on-campus employment for an F1 student. An F1 student may accept on-campus employment with the approval of the designated school. The work must take place either at the school or at an educationally affiliated, this is something that's associated with the school's established curriculum or part of their funded research program, for example. Work that takes place at the school location could be for an on-campus commercial business, such as a bookstore or cafeteria, which is normally what comes up, if the work directly provides services for students. Employment located on campus that does not directly involve services to students, such as construction work, does not qualify as on-campus employment. Work with an employer that is educationally affiliated with the school is on-campus employment, even if the work site is not located on the campus, such as a research lab that is affiliated with the school. And this on-campus employment can't displace a US citizen or green card holder. The employment may not exceed 20 hours a week while school is in session, but it is permitted to be full-time when school is not in session. And at all times, the student must be maintaining their status. So, for example, an F1 student who finishes a program, such as a bachelor's degree, and starts another program of study at the same campus may continue on-campus employment if the student plans to enroll in the new program of study for the next year. Off-campus employment for an F1 student. An F1 student may not accept off-campus employment without first applying to USCIS for their employment authorization, that I-765, that permission to work. An F1 student may be eligible to apply for off-campus employment authorization after completing one full academic year in F1 status. That's typically after 9 months. If a student receives their work permit from USCIS, to work off campus, so to be employed off campus, they cannot work more than 20 hours per week when school is in session. The employment authorization will automatically be terminated if the student fails to maintain status. And this will have a knock-on effect, not just on the employment, but it will also have a knock-on effect that if you do this, it will impact either future extensions, future change of status, and definitely impact future green card holders. So you cannot fall out of status and continue to work. That's deemed to be unlawful employment. I often get asked about practical training. All students are eligible for practical training only after they have completed a full academic year in an approved college level institution except for graduate students whose program requires them to participate immediately in the Curricular Practical Training, CPT, that acronym, that's what that stands for. Students in English language training programs are ineligible for practical training. I just want to clarify that because I said all students. Optical practical training, OPT, that acronym, is training that is directly related to an F1 student's major area of study. It is intended to provide a student with the practical experience in their field of study during or upon completion of a degree program and is authorized through the recommendation of the designated school official and the filing of the Form I-765 with USCIS and subsequent issuance of this employment authorization by USCIS. It's important to note that the CPT is employment that is integral part of the student's specified curriculum. It involves internships or similar work experience specifically required by the student's program of study. And it must be authorized before the student begins work. Optional practical training is when an F1 student may apply for the optional practical training, OPT, in a job related to their major area of study. OPT may be authorized pre and post completion and on full-time or part-time basis. During school vocations, either part-time or full-time OPT is permissible. When school is in session, OPT may not exceed 20 hours per week. OPT is different from the curricular practical training, the CPT, which is part of a student's degree curriculum and can only be authorized during a student's course of study. OPT, by contrast, can be authorized during the student's degree program as well as after graduation. So a big distinction there. Practical training for an M1 student. So except for temporary employment for practical training, an M1 student may not accept employment. Practical training is only authorized at the completion of an M1 course of study. An M1 student who desires temporary employment for practical training must apply to USCIS for their work authorization. That's by filing Form I-765 and the requisite evidence. If approval is granted, then DHS will endorse the student's Form I-20 with the dates when the authorization for practical training begins and ends. Because M1 students are admitted until a certain date, an M1 student may need to also file Form I-539, that's an application for an extension or change of non-immigrant status, to apply for an extension of the M1 status in conjunction with the application for the employment authorization. Employment of F2 and M2 spouse and children is not permitted. The M2 spouse and children of an M1 student may not accept employment. The F2 spouse and children of an F1 student may not accept employment.